Okay. It is 7 o'clock p.m. Central Standard Time. Today is Wednesday, April the 27th. Welcome to week number 4 of Introduction to Corrections. My name is Richard Wright, and I just want to remind you that as of now, you cannot turn in any assignments from week 1 and 2. If you turn in assignments from week 1 to from week 3, be aware of the fact that week 3 assignments were due Sunday, and you have 6 days to get those in to get any points at all. So just be mindful of that. But weeks 1 and 2, you cannot submit at all. We are now starting week 4. If you have any questions, reach out to me. And be aware of that. So, all right, let's go ahead and let me share my screen. All right, and so here we are in the grade book. You'll see that I have graded weeks 1 and week 2 completely. You will see that for the week 3, I have graded everything except I have 10 written assignments to complete. Those will be completed by Friday. Okay, so, and then this week, we're dealing with the written assignment of the probation officer. I'll talk about that. And intermediate sanctions, as well as your quiz and then your live classroom. Okay, so be aware of that. So let's take a look at the calendar so you can see where we are. We're near, as we say, in the second half. Starts to accelerate because of the fact that the second half is a shorter period. So this is where we are right now. Your initial posts were due on Tuesday, yesterday. Your live lecture, your reply post is due the 30th. Okay. Your written assignments are due May 1st, along with your quiz and live classroom phrase. Okay. And be aware that next week will be the last lecture that we have in this class because there is no week 6 lecture, but I'll be covering week 5 and 6 during that lecture for that Wednesday. All right. And then the course ends on the 10th. Absolutely no assignments will be accepted after 11:59 p.m. Central Standard unless you have previously requested an incomplete. You don't go to your dean, you don't go to your advisor, and to be honest with you, you need to come to me. But I wouldn't send an email if I were you. I would text me or call me to talk to me about it because I'm not going to base it on what you say alone. I'm going to look at and see how much work has been done and to see where we can go from there. All right. So the 10th is the last day of class. The term 2 begins the very next day. Let's go back here. So let's take a look at the announcements. Week 4. So in week 4, module 4, prisoner rights and evolution of probation. We'll talk about probation officers and chapters 8 and 9 of the textbook. I already sent you those PowerPoints. And we're going to go over the law of corrections and prisoner rights, Bill of Rights of community supervision, corrections law, and prisoner rights. And then we're going to deal with sentencing, sanctions, and then a vocabulary review and the evolving role of the probation officer. I'll show you briefly how that works. The discussion assignment, intermediate sanctions, was due yesterday, 11:59 p.m. Central Standard, and your reply post due Saturday at 11:59 p.m. Central Standard Time. Your written assignment, probation officer, and then your quiz, which is timed, as you know, is due this Sunday, along with the key phrase. If you haven't done so, the mid-quarter student survey, I think it's still available if you had a chance to. So I encourage you to finish strong and recognize my motto, adversity is a springboard to success, which I shared with you as in an announcement here. Here it is. It's been there the whole time for the course. Okay. So let's look at prisoner rights and evolution. So here's your written assignment for this week. So you have this scenario, all right? And what you're going to do is you're going to create a job announcement for the probation officer's position, summarizing the continuing of probation officer's duties. Describe 4 roles of a probation officer. Include examples of what the probation officer is required to do in fulfilling these roles, such as surveillance, broker of service, liaisons of the court, change agents. Provide details. Don't just use the words and terms. And it says provide supporting evidence from credible sources. What does that mean? That means this is APA. In the document, there should be citations, not a citation, citations to support where you got the information that's included in your job announcement. Very important. If you don't provide them, you're going to end up, as you'll see in a few minutes, with 55 or under. Professional language, grammar, and spelling must be in a Word document, a cover page, as well as a reference page. Should be double spaced people, not single spaced. Okay. Well, since it's an announcement, I'll let you do it single space. Okay. But you still got to have those citations in the body. All right. Let's look at the rubric. So if you have incomplete or confusing summary, that means you don't have citations in the body. See, no credible sources, no credible sources, no credible sources, and you're going to end up over here. If I don't see them, I'm telling you, I can't put you over here or here. But what I encourage you to do is to provide credible sources dealing with the exemplary summary of the continuum of the probation officer's duty, as well as exemplary description of each role with thorough supporting evidence from credible sources and examples. All the way down is credible sources. If you don't have them, you're going to run into a problem. Make sure there's no spelling errors, typos, and things of that nature. So right away, I can hear students already say, why did I end up losing so many points? Because I didn't have credible sources. Because we use a rubric, it puts you in a column and it describes what you did not do. No credible sources over here, all the way down, okay? And then I will tell you that as well. Very important. And remember, citations in the body and reference page, separate reference page. Very important. If you get a 55, you're not passing. All right, and you can't do it over again, by the way. Intermediate sanctions, which we're going to talk about, and you're going to use this scenario, and then you're going to, in your initial post, explain the intermediate sanction to use for Pat's violation, support the sanction selection and say why you selected it. Include problems, issues, and then in your response, respond to one of your classmates. Okay? And again, you will not see the discussion of other individuals until you post your own initial post. Then you have the quiz. I'm not going to click on that. Your live classroom recording, which will, by the time you see it, this will be gone, and it will have the link, as well as I will send it to you by email as well. So some of you might not even know about that because you get the email. Okay. And then your live classroom phrase goes here. So let's talk about these issues here. Okay. All right. So let's start out by talking about the law of corrections and prisoner rights. Okay, so it's pretty straightforward that the Constitution of the United States, statutes, the legislation that is passed by states and all levels of government, from the federal down to the local, and cases interpreting those statutes are what we utilize to establish the legal rights. Then there's some regulations that are made by the federal, state, and local administrative agencies, the Department of Prisons or something like that, and set up an agency for the executive branch, which in the case of the states is the governor. Okay, in the state, in the county, then it's usually the county board president. In the local, it's the mayor. Okay. And then, of course, in the federal government, you know, it's the president. All right, so various agencies. So now, the Bill of Rights, as you already should be aware of, first 10 amendments provide the rights for individual citizens generally. The 14th Amendment applies those first 10 Bill of Rights to the states. And so due process hearings, due process where you have an opportunity to respond to allegations that are made before you can find yourself incarcerated. So it says here that before the 60s, the court had a hands-off policy, which means pretty much that the correction agencies were able to do pretty much what they left done based on what the state law says. And it says, while some states use their constitution, because they're their state constitutions, to deal with the issues in the jails and prisons, others followed the belief that incarcerated individuals didn't have any legal rights at all. But that has since changed. That has since changed with the evolution of various cases, which I'm going to just briefly touch on. All right. So dealing with the First Amendment, where, you know, it talks about Congress shall make no laws dealing with religion, prohibiting the free exercise of religion, freedom of speech, press, the right of people to peacefully assemble and petition the government. So there are various cases that came about from on the First Amendment from 62 to even now, but 2006, the last one here, where various beliefs were recognized, as in 62, the Muslim faith. And then in 74, it was decided by the courts that censorship is necessary of the mail. So in other words, your mails while you're incarcerated are subject to review by the prison leadership and officials. A case in 1987 said that the rights of Muslims are not violated when work makes it impossible for them to attend religious services if no other alternatives exist. So in other words, you can't say I have a religious belief and I cannot work. It's not going to fly. Incarcerated individuals don't have the right to receive mail from one another, and this mail can be banned if it's related to um, protection or could present a security issue within the facility. In 2006, prison policies denied magazines, newspapers, and photographs to the most incorrigible residents in the prison system in an effort to promote security and rule complaints. And the court said that's constitutional. Let me explain something to you. First of all, number one, there are various types of magazines that they might allow. But let me tell you something that happened with one of my clients, a young man who was a security guard, who was a correction officer in Cook County at the jail. He lost his job because he was bringing magazines that were given by the family members of the individual uh, sent to him. Now, they weren't pornographic or anything like that. They were just, they could be Time magazine or Newsweek or anything. But here's the problem, is that it was determined that this was a way of smuggling in drugs. Not that it was in between the pages, but here's what would happen, is that the pages of the magazine were soaked in PCP and or another liquid drug, allowed to dry, ironed out, and then given to the prisoner. So what do you think the prisoner was doing with the magazines? They weren't reading it, they were chewing the pages and getting high. So because of security reasons, those kind of things happen. So the prison itself may provide certain magazines in their library for residents themselves, but there's no absolute right there. The Fourth Amendment, which we should be aware of, deals with search and seizure and warrants. And so in 1962, it was made clear that conversations can be recorded um, in a jail visitor's room and are not protected by the Fourth Amendment. In other words, they can listen in, except with attorneys, and that's because of attorney-client privilege. A warrantless search of a cell is not unreasonable because cells can be searched at any time, and any evidence that's found cannot be suppressed. It is not reasonable to expect a prison cell to have the same level of privacy that you had when you were at home or an automobile. So in other words, you give up those rights. Strip searches are carried out when necessary and when such outweigh the rights to be invaded. And the reason for that is because there have been drugs that were smuggled in. Officials may search cells without a warrant and seize materials. So your Fourth Amendment rights are relaxed, okay? And the prison has the ability to be able to do that without violating the Constitution. The Eighth Amendment has to do with excessive fines or cruel and unusual punishment or excessive punishment. Now, in 1976, deliberate indifference to medical needs constitutes unnecessary and wanton infliction of pain, and it violates the Eighth Amendment. In other words, while you're incarcerated, you should be entitled to medical assistance and treatment. If the conditions of the prison are inhumane, and there's an organization called the John Howard Association that goes around checking those kinds of things. But if the conditions are discovered to be inhumane, then that's a violation of the Eighth Amendment or cruel and unusual punishment. It cannot be successfully argued that double selling constitute cruel and unusual punishment because of the space limitation. And it must be shown that the condition involves wanton and unnecessary infliction of pain. But the key thing is that double selling generally is acceptable. A prison resident mistakenly shot in the leg during a disturbance is not suffering cruel and unusual punishment if the action was taken in good faith to maintain discipline rather than the mere purpose of causing harm. You should be aware that there are excessive force cases that do take place in prisons, and they can be successful. And so the prison guards or the correction officers or whoever are held to the same standard as law enforcement when it comes to utilizing excessive force as well. Plaintiffs must not only prove that conditions are cruel, but also have to show that they exist because of indifference. In other words, that the officials just don't care. This is a 2003 interesting one, which is pretty common here now. Regulations suspending visiting privileges for 2 years can be utilized if you flunk 2 drug tests and it doesn't constitute cruel and unusual punishment because it has to do with a legitimate penological interest. That is, to not allow drugs to be smuggled into him, or for the inmates not to be high on drugs. We conclude with the 14th Amendment. Remember, I said earlier that the 14th Amendment applied the first 10 amendments to the states. Prior to that, it was applied to the federal government. So in 1968, the law in Alabama that was used to segregate white from black individuals is unconstitutional. You cannot do that. Now, you can segregate individuals based on violence or something like that, but you cannot do it just based on their race. The elements of procedural due process must be present when decisions are made concerning disciplining a person in prison. In other words, you are entitled to a copy of the charges, you are entitled to representation, you are entitled to confront your witnesses, and to be able to prepare an adequate response or defense to any allegations before any disciplinary action takes place. Now, it said in 76, although due process must be accorded, it said an individual has no right to counsel in a disciplinary hearing. I believe that has changed since that time, because if it involves jeopardy in serving time in prison, and not just a minor offense, then in that case, you do have a right to counsel based on the Sixth Amendment. The involuntary transfer of an incarcerated individual to a mental hospital requires a hearing. That's, once again, we're talking about due process and all those elements that I had talked about earlier. And then finally, prison regulations don't violate due process unless they take you out of the group and pick on you, and it's a hardship that results in you're being disciplined or singled out. So these are just some of the issues involved here, and so why this is sounding, I don't know why. It's not supposed to. This is the second time this has happened. I don't know why it's sounding. It's not supposed to. Anyway, it is always true of probationers that they have that they don't enjoy the absolute liberty, as I was talking about earlier, but they have liberty based on the conditions or restrictions that are issued while they're on probation. All right. And these are just some of the things. So I guess what do you gather from all of this is that individuals who are incarcerated, their rights are limited, but they still have rights. And it's determined on cases um, that come before the courts. And then this is just a little uh, section here where you can go through and you can look at some examples of cases where various issues took place. So in Griffith versus Wisconsin, it was determined that the warrantless search of a petitioner's residence was reasonable within the meaning of the Fourth Amendment because it was conducted pursuant to a regulation. So we're talking about probation, uh, dealing with the issue of that person being subjected to the probation conditions that were issued by the court and under control generally by the probation officer. Pennsylvania versus the Board of Probation and Parole versus Scott, evidence that would be barred by the exclusionary rule from the use of a prosecution in a criminal trial can be used in parole revocations. So why is that? Because the exclusionary rule applies to criminal cases where there is a different standard, and that is beyond a reasonable doubt. In parole revocation or probation revocation, there is the standard of proof beyond, not beyond a reasonable doubt, but the civil standard, and that it's weighed on whether it's 51% that you did it or not. Remember, reasonable doubt requires 100%. All right. Let's go to the next one. And let's look at this case. A probationer has a right to counsel in revocation and sentencing hearings before a sentence can be imposed. So you have a right to counsel based upon the Memphis case. A hearing officer determines if there is probable cause that a violation occurs. But you have a right, as I said earlier, to be notified of the charges, know the evidence, speak on your behalf, present witnesses, confront the witnesses as well. At a hearing for revocation or for a parolee, you must receive notice of the charges, disclose the evidence, cross-examine and receive written statements outlining the evidence and the reasons related to that. So the key thing that you need to be aware is that in the probation case, the revocation applies to the same, but you have a right to counsel. I said that earlier. I thought that had changed, but not for prisoners themselves, all right, in all cases. But the Morrissey versus Brewer has to do with the hearing officers and the parolee rights, and before their parole is revoked. And then finally, Gagnon versus Scarpelli. The rights established for parolees in the Brewer case also apply to probationers in 1973. So what we had talked about a few minutes ago, the right to counsel, granted on a case-by-case, depending on the complexity of the issues, mitigating circumstances, and the competence of the probationer. That is why I said what I said a few minutes ago regarding probation. Cooper versus Pate, a 1983 case, which is a section of the United States Code where individuals who are incarcerated can bring lawsuits against correction officials. But it applies not only to incarcerated individuals, but to those on probation as well as parole. So they can file actions against the probation officer, parole board, and so forth. And that's the end of that. Okay. I think we just did this one. We did. So let's deal with the sentencing and sanctions. So both jails and prisons where individuals are held. Remember, jails are for short-termers or for individuals convicted of crimes that are less than a year. And the jail sentence can be the sole sanction, or a jail sentence may be a condition of probation. The goal of community supervision, though, probation, is to let the person out and to utilize what we call intermediate sanctions, where what we do is we allow that person some liberty and some freedom. And you might have to wear an ankle bracelet, or there might be certain hours that you can be out or not be out. If you're involved in a drug situation, you have to participate in drug treatment, and then you may be subject to drug drops and tests. And so intermediate sanctions are an attempt to keep the person out of jail, because I've already said this before and I'll say it again, it is cheaper to educate than to incarcerate. So the point of the matter is that with an intermediate sanction, you're going to be responsible for reporting to your parole officer, and you can find yourself, based upon how well you're doing, maybe decrease the number of times that you might have to report per month or per week. When a court sentences someone to probation, the judge established conditions, and I mentioned this before. They might have a fine or require drug and alcohol treatment, or to seek to get a job, and the probation officer generally helps with that. So you would find yourself, as long as you're satisfying the requirements of your probation, whatever they are, you can serve the remainder of your service outside. But if you VOP, what we call violation of probation, you could serve the remainder of your sentence in jail or prison, depending upon the offense. So the key thing is to give you an opportunity to prove that you've learned something, and to help you to, as we say, reintegrate into the community. So intermediate sanctions can range from fines to working in community service, drug and alcohol treatment, reporting, day reporting centers, where services such as employment, alcohol treatment, education, drug controls, home confinement, where you will also have an electronic monitor, shock incarceration. A person is sentenced to jail and prison, but after a short duration of roughly 30 to 90 days, the judge reduces the sentence and assumes that the individual may have learned the lesson, and the person will be indicating that they want to be a law-abiding citizen. In other words, they're on their way from 12 o'clock to 6. You know what that's all about, because I've talked about that already in this course. Boot camp. That's where a person is put in a military type situation, workouts, the same way as if they were in the military. Drills, marches, hard labor to develop respect for authority. And so these sanctions are there to help individuals to change from the ways that got them there into becoming a productive citizen. Okay. No probation officer that I know wants to lock somebody up for a violation of probation. However, it depends on a case-by-case basis, because the idea of probation is to give you a chance not to be behind bars or stay behind bars. But if you don't satisfy those requirements, sometimes they will modify the terms to help you more, but it depends on the specifics, and it's determined on a case-by-case basis. I would say that many individuals might violate the conditions of probation, sometimes based upon situations that may not have been that serious. But the point of the matter is that any violation could subject you to losing the opportunity for intermediate sanctions and be sent to prison to serve the rest of your term out. All right. Whoops. Didn't mean to hit that again. Meant to hit this one. And so the probation officer is so important in the lives of individuals. And so we're going to spend a little bit of time that we have here remaining and talk about how the probation officer operates. Now, be aware of one thing up front. The probation officer is a person who has been college trained. That is, most jurisdictions that I know, the minimum requirement that you have to be a probation officer is a bachelor's degree. So if those of you who are considering becoming probation officers, you're going to recognize that you need a bachelor's, and you're going to see some of the conditions that you are required to fulfill. It's almost like a social worker, and you'll see. So let's take a look at this, how it's worked. So let's look at some of the roles. These are says that the probation officer is kind of like a police officer, but it includes supervision and surveillance of those individuals while they're on probation. And the whole idea is to utilize those, how should I say, terms for probation to restore that individual to society. And you're going to see in a few minutes that restorative justice philosophies and evidence-based practices have changed how probation and parole officers operate. Here we go. So over the 30 years, you'll see that it has become more. And we're going to go starting from 80, pretty much. So these are some of the main duties that were in existence in 1980. and they were pretty minor. You dealt with the home employment and office visits, PSI, which is pre-sentence investigations. You prepared reports if a person violated the conditions of their probation. Transfer investigations, where sometimes probationers are moved from one jurisdiction to another. And then before being released from prison, investigations. And of course, the court appearance and testimony. Now, that right there sounds like um, what you might think a probation officer does. However, though, that began to change over 16 years later. The duties that I just gave, and now we add on uh, annual update to the court, which progress reports, evaluations of bail, preparing sentencing guideline worksheets, conditional release of form that determines to what level of supervision that an individual has, whether parole or probation, determination if there's a fine, transporting individuals, program monitoring, community service work referrals, hoping that individuals will sometimes work within the community to get them back on track, and then making sure that there's no gambling. And so from 96 to 2009, in addition to those that we talked about earlier in from 80 to 96, you also dealt with restitution services, where there were instances where probationers had to restore the individuals that were their victims. Because of the sentencing issues, victim impact and neighborhood impact. In other words, individuals were allowed to submit statements that the probation officer would have to prepare, and they would end up being a part of determining the extent of the sentence, not just the sentence, but also the conditions of probation or parole. Assessment testing, depending on what kind of offender you were, sexual offender. They also can involve themselves in DNA testing, determine the violence of the individual, risk need analysis, and of course, drug testing, as we talked about earlier, and other types of things. Look at on down motivational interviewing, case planning, school district notifications, so they notify the schools that there's a probationer in their area. Sex offender, if a person is a sex offender, the probation officer has responsibility of making sure that registration takes place. Intensive supervision, electronic monitoring, and diversion programming. So the key thing is that you're involved with more monitoring of the individual than initially back from 1980. And now, the reason why we say bachelor's is because assessments of proficiency are involved, core correctional practice skills, determining the relationships that individuals have, who they spend time with, uh, cognitive restructuring, that is trying to get them to focus their minds on things that will not get them in trouble, anti-criminal modeling, so that, again, giving them some positive role models to work with. R&R, we talked about that before, the responsibility principle, the risk need, and treatment and dosage principles, that drugs, alcohol, and so forth. You have case planning, quality assurance, and research. So probation officers have to, as they say, constantly write reports, keep reports, and how the individual is doing. And those are things that the responsibility of the probation officer. So you see, it's more like a social worker today now. Okay, now let's talk about the final thing of being a change agent. So what is a change agent? The probation and the probation or parole officer is not only responsible for public safety, but also for working individually with offenders to provide skills, vocation opportunities, educational opportunities, to restructure their criminal thinking. Again, getting the individual from 12 o'clock to 6 o'clock, having them to do a 180 in their lives so that they're no longer participating in criminal thinking, so that they won't find themselves being recidivists. And that's the end of that. Okay. So now let's look at the vocabulary review. These are some things that you'll want to study yourself, but I'm going to just show you because before you take the test. A judicial policy of non-interference concerning the internal administration of prisons. We talked about that earlier. You thought that was it, didn't you? Let's go back. I can show you what it is. Let me get you back. And the reason why I did that is because a lot of people think that that's it. But we talked about that. But a judicial policy of non-interference concerning internal administration. This is what it is right here. Case law. Case law. Let the cases themselves decide. Let's go back again, and you'll see why. Because it's determined on a case-by-case basis. So you don't want the hands off. It's not the procedural due process. It's determined on what the cases do. Okay, case law is what decides those rights. The constitutional guarantee that no agent or instrumentality of government will use any procedures other than those procedures prescribed by law to a what? Is it hands off? You know it's not case law. Okay, you want to try that one? Let's see. Nope, it's procedural due process. I knew that because that's one of the most important things that you're going to discover, that the rights of individuals to hearings, to have a response. Okay, so we know this is case law. And then we continue. And so this is it right here. Okay, so you can go over each of these on your own and you can study them to get you ready. Okay, so that's about it I have for today. If you have any questions, you reach out to me. I'll give you a phrase today. Probation officer. That's the one I want you to use for today. Give me probation officer and you get your points. Okay, again, feel free to reach out to me with any questions you might have, any clarification about something I might have said. But in your readings, you will find most of what I talk about. Okay, good night.